Good afternoon and welcome to the law. This is your legal light. It is your health law. It is our weekly legal clinic. And this is where we help you to understand the law for yourself and perhaps for who else. I'm Samson, Lardy, Anyenini. We are treating divorce, distribution of matrimonial property or distribution of property. We'll help you to understand what exactly matrimonial property is, and when the process of divorce is over, what property, what share you are entitled, what it is that you cannot get. We'll be right back. You're welcome back. This is the law. It is your health law. It is your legal light. And I'm happy to welcome two lawyers, distinguished in their own rights, and who have had something to do with the subject that we are going to discuss. They're going to help us understand in fuller detail what it is that will be distributed or will not be subject for distribution when a marriage is over. My guests, they are both no strangers to you on the show. Iris Agre-Orleans is partner, Bayou and Co. Randolph Chumesi Ankra is partner, Morrison Chumesi and Partners. For now, let me welcome Iris Agre-Orleans. Thank you so very much for making time to join us on the law. Please unmute your mic.
Thank you, Samson. I'm happy to join you.
Great. So we are excited that you are able to make time to assist us once again, like you have done before, to help us with the critical legal education that we all need. And I have realized that on social media, there's already such a buzz on the back of the flyer or the announcement that we're going to have this discussion. So for starters, when we are going into the courtroom over a marriage that the parties no longer want, under what circumstance will, for example, the marriage be said to have been ended?
So under the Matrimonial Causes Act, and that is the act that determines issues about dissolution of marriage, the only ground upon which a court will dissolve a marriage is that it has broken down beyond reconciliation. And in order to prove that it has broken down beyond reconciliation, the petitioner must show, and the petitioner is, I'll use the common language, the plaintiff. So the person who brought the matter to court will have to show the court that either the person has been unreasonable in their dealings with the person. You can show the court that the person has committed adultery, and by reason of which you cannot continue to live with the person. You can also show that you haven't lived together as husband and wife for the past 2 years, and that the other party is also agreeable to the divorce. And when you say you haven't lived together as husband and wife, what you need to show is that the ordinary incidents of marriage, you haven't cohabited as husband and wife for 2 years and both parties are in agreement. You can also show that indeed you haven't lived together as husband and wife, and for that one, you don't, for the past 5 years, immediately preceding the petition. And for that one, you don't even need to show that the other person is in agreement. So it is as if the person has deserted the marriage. So these are some of the things that the courts will look at in holding that the marriage has broken down beyond reconciliation. Apart from that, you must also show that you have taken certain diligent steps and efforts to attempt to reconcile. And even though you have taken those diligent steps and efforts, they have proved unsuccessful. So yes, you prove these things, and then the court would say that indeed the marriage has broken down beyond reconciliation, and then the court will dissolve the marriage.
That's a lot within very, short, less than 2 minutes, in summary of the factors that a court will consider to say a marriage has been brought to an end. From where you sit, what else will you add to the issue when we say there has been a divorce or a marriage has been annulled? What do we mean? We are going to the property and how it will be distributed, but we need to first establish the grounds that there is a dissolution of marriage.
So when we say a marriage has been dissolved, then it means that the parties have, like my colleague said, a petition has been filed, evidence taken, the court has heard the parties come to a conclusion that the marriage has broken down beyond reconciliation. And because of that, the parties can go their separate ways. So the court will give a decree of divorce, or in cases where it was for a nullity. And because I've mentioned that, let me just bring a bit of distinction. Divorce, applying for divorce on grounds of any of the factors my colleague mentioned is different from applying for divorce or applying for nullification of the marriage. Because to apply for nullification of the marriage, several factors also must be in existence, such as maybe the person you're married to, if it's a man, the man doesn't have the means to possibly even satisfy you as a woman, or the man had a disease, or a party had a disease that they concealed from you, or there are certain factors that, by virtue of that, if you knew, you wouldn't have gone into the marriage in the first place. Then you can ask for a decree of nullity. So it will be as though the marriage did not exist in the first place. But with divorce, yes, you concede that there was a marriage, but due to some challenges or due to certain factors, you cannot continue living as such. So the court will just give you
some very basic things. There are some people who are often not sure who is entitled to approach the court. So the husband is not sure, the wife is not sure. Who is entitled to go to the court first and say, I want this marriage, to come to an end?
Oh, as for who is entitled to go to court first, the party who believes that they can no longer stay in the marriage, there's no restriction by law on who should approach the court first. So if you are the one aggrieved or unhappy or have a reason to walk out of the marriage after several efforts to reconcile have failed, you can apply to the court for such a remedy. You don't necessarily need to. More often than not, yes, by practice, you realize that one party can say, I want to wait for him to go first, I want to wait for her to go first. It really doesn't matter whether who goes first. What matters is whether the grounds outlined in the law have been met for the purposes of the court granting you the divorce. It doesn't matter who goes first.
And the most important determination, as Iris said, and you have also corroborated, is that the court must come to a conclusion in the end for a divorce that the marriage has broken down beyond reconciliation.
Exactly.
Elsewhere, they will say irretrievably broken down. It's broken down to the extent that we can't take it back.
And like we say when we are making submissions in court, that this is irredeemably bad.
Irredeemably bad.
So we cannot even revive it no matter what we do.
Right.
So in such a circumstance, the court will just say, you know what, go your separate ways and then see what life has to offer.
That brings me to the next point. And Iris, is there a situation where the court will say, I've listened to the two of you, husband and wife, and a strange couple, but I don't think your marriage has actually broken down beyond reconciliation. So go back and marry and continue your marriage.
Yes, indeed. It has happened before. It has happened a few times. What the court usually recommends in these situations isn't that go back and marry, but go and seek counseling. So a court can tell the parties that I'm not convinced that both of you have put in the work in reconciling. So I'm going to give you 6 months. In that 6 months, I expect you to go to a counselor of your choice. during that and then report back to the court after 6 months where you have gone through the counseling. There is also what we call the court-connected ADR. Sometimes courts refer the parties to the court-connected ADR experts who would sit with the parties and attempt to reconcile them. And if reconciliation fails, what may happen is that they may make recommendations as to a settlement of the issues between the parties after the divorce. So yes, you must necessarily convince the court that the marriage has broken down, and they have the power to order you for counseling.
Right. So we are now going to go into the questions of property distribution, when that question comes up in the first place, in the process, and how it is handled. But, you know, because of this thing that you guys have just said, it reminds me of the necessity to ask this, because it's a practical thing that faces lawyers all the time, that somebody comes to you, and to the two of you, I want to see how many, what your list will be, and Iris, what your list will be, of the things that you need the person to show that in fact the marriage has broken down beyond reconciliation for a court to accept the same and then end the marriage. Iris, what will be on that list if somebody approached you and they were asking you to lead them to court? What will you require as evidence that the marriage has broken down beyond reconciliation?
So once again, we'll have to go back to the checklist that is provided under the Matrimonial Causes Act. And as I've enumerated the things, so I'll ask you questions about how long you have lived or you haven't lived together as husband and wife. If you haven't lived together as husband and wife for 2 years and the other party is in agreement, what we may require for you is to get that agreement in writing, that indeed both parties will say that we haven't lived together for 2 years and here is my agreement in writing. In terms of unreasonable behavior, whether it is a matter of emotional, physical, or other abuse, you must show certain things. If, for example, there's been physical abuse, has there been reports at the police station? Do you have any police reports? Do you have any pictures? Do you have any incidents that will help us convince the courts that what we are saying is true? In terms of adultery, has anything happened? Do you know the name of the other person? And what are the incidents that happened that led you to believe so? Because it's been said that hardly would you ever catch somebody directly in the adultery. It will be incidents and matters that would lead to that. So these are some of the things that we will ask you, and we would, once you let the lawyer know, what they would do is that they would explain those pieces or put together those pieces of evidence in such a manner that a court would appreciate it as evidence of proof of breakdown of marriage.
Thank you very much. You want to add to that checklist?
Yes, I want to add a few to what my colleague has said. Sometimes to what some of the things you may want to find out, especially if the grounds for the divorce is irreconcilable differences. You do want to know from the person sitting before you what the challenges that they are facing in the marriage is. So for instance, if it's an issue of childbirth, and maybe the woman needs a child, and then all the medical data shows that the problem is from the man, and the recommendations, medical procedures have been recommended, and the man is failing to comply with same, that can constitute an irreconcilable difference, because one wants a child, one doesn't. It can even fall under unreasonable behavior. So you want to look at the particular incidents of the differences that the person is talking about, and the efforts they have made to reconcile same, which have failed. And also you'll be looking at, in cases of maybe desertion or not living together as husband and wife, you'll be looking at the last time they had sexual intimacy, how living in the house has been. There are instances where people are married, but they are unmarried, so to speak, because in the house, one sleeps in a separate room, another sleeps in a separate room. They've been living together, but they are apart for like 2, 3, 4 years. There's not been any form of intimacy between them. So you want to know whether these factual situations exist to found your ground for the divorce. Because without premising your facts within any of the grounds stated in the law to establish that the marriage has broken down beyond reconciliation, you cannot even go to the court in the first place.
Thank you very much. If you just joined us, this is the law. It is your legal light. It is your health law. And my guest, Aris Agri Orleans, the partner, Bayou & Co. And also right here, and the man you just heard is Randolph Chumesi Ankra. He's also is a partner with Morrison Chumesi and Partners, and they're helping us to understand what is property within marriage setting, and when the marriage has ended or a divorce has happened, how will the property be distributed? And I'm sure many of you will be aware of an interesting story that has been going around in the course of the last couple of weeks. But around that same period, there is something more important that has happened in our own courts that people may not have paid attention, and it has to do with the same issue of property. So we have the best to help us deal with that situation. Aris Agri Orleans, as you may have encountered her, managed a very contentious matter in the property or distribution matter regarding the divorce of a famous person, a footballer, one of Ghana's best footballers that we've ever had. So she has quite some good experience in that to help us. So get ready with your questions at the right time. We will have you ask your questions and they will have answers for you. So Aris, let's begin this way. Who can look up to get what after the marriage has been declared as it's been ended by a court of law?
So the law is that property jointly acquired or jointly acquired assets upon divorce shall be equitably distributed. And that law is gender neutral, and it's Article 22 of the 1992 Constitution. It is gender neutral. So both man and woman can enjoy and should enjoy from jointly acquired property upon dissolution of the marriage. There must be an equitable distribution. And when you say equitable distribution, the courts have historically used the words as fair play, common sense, when it comes to the equitable distribution. So on a case-by-case basis, both parties can enjoy marital assets.
Just recently, many Ghanaians have celebrated you for this particular case that I referenced a while ago. There had been the attitude that the court says you don't really have to have contributed to anything in the marriage, in the property making. You will still be entitled to as much as you can get. So what you are referring to, how different is that? Because you are talking about property that is jointly acquired by the couple.
So there are two aspects of this, and I think that is where sometimes the confusion comes in.
Great.
There's what we call financial settlement or financial provision, and then we have the property distribution. So with financial settlement and financial provision, it is under Section 19 of the Matrimonial Causes Act. In that, it is a just and equitable award of financial provision considering the standard of living of the parties. So when it comes to that, what you are claiming is not based on what you have put in. What you are claiming is based on the fact of marriage, being that the parties have married, you have been reliant on the income of one party, you have been given a certain standard of living for a certain period of time, and you have reasonably expected to continue to enjoy that standard of living. You have acted in detriment to yourself, and therefore the court will look at factors such as the income earning capacity, the standard of living, the age of the parties, your individual needs, etc., and then make an award of financial settlement. That's separate. Then we have property distribution, where you are looking at property that was jointly acquired in a marriage. The two of you have put together resources, and I will not use the word money, because resources could be time, could be energy, and it could be money. So you've put together resources to acquire property. Upon divorce, whether or not that property is registered in another person's name, that property becomes matrimonial asset, and you are entitled to enjoy that equitably. Equitably does not mean equally. In some instances, it will mean equally. In others, it will not mean equally. And so you would have to look at the intricacies of every case.
Okay.
We can look at it as if two people are filling a barrel. One person has a smaller bucket, the other person has a bigger bucket. Obviously, the bigger bucket will fill the barrel faster. It doesn't mean that the one who has that smaller bucket is not filling the barrel. And so the court will not look at the ordinary incidents of commerce, where it will say that because Amma brought in 5 cedis out of her salary of 10 cedis, and Kofi brought in 10 cedis out of his salary of 20 cedis, suddenly Amma and Kofi's contribution to the property is not equal. You would look at all those incidents and then come to a conclusion whether it should be equally distributed or it should be distributed in a 30-70 portion or 60-40 portion. Okay. So it is on a case-by-case basis.
All right. And we will seek to also establish what is it that really constitutes jointly acquired property. Must it be, for example, if it is a house, that there will be a document that shows that it is for the both of us, or that there are circumstances where it will not be in that situation, and yet it can be deemed that it is jointly acquired and therefore it must be shared equally. Now, Randolph, there's education that you sought to give because people were acting on a certain misguided premise. Because of this recent footballers issue that came up, suddenly people were saying, well, guys are now beginning to realize that it's good to hide your property under the name of your mother, and when there's divorce, the wife will not get anything. But first, what is guaranteed for either party after the marriage has ended in terms of property? So
my colleague has said a lot of things, but just to add to it, I just want to, before we even go, if I can just give a brief. You see, our law has evolved from a position where hitherto women did not even have rights at all in properties jointly acquired in the course of marriage. And then we evolved to a point where the courts required, in fact, a point where we had to quantify. We were supposed to quantify your contribution in monetary terms. So if you're able to establish that, oh, I contributed a penny or a peso towards the acquisition of the land or towards the construction of the property, then I am entitled to some portion of it. And then gracefully, in Mensa and Mensa 98-99, her leadership, Bamfordado, laid a roadmap that no, we cannot be requiring financial contributions from women. We should look at contribution a different way. So the roadmap was laid where we had to look at distribution equitably. Now, if you are on the path, if the marriage comes to an end, the law, as you rightly stated in Article 22, says that properties, first, the properties must be properties acquired in the course of the marriage. Second, they should be jointly acquired from the resources of the parties. So to the extent that the property can be shown to have been jointly acquired, a spouse who makes a claim for a share in that property and is able to established before the court that indeed this is it, will be entitled to a certain portion, which the court will determine the portion you're entitled to based on the facts of that particular case.
You began by saying it must have been acquired during the course of the marriage.
That is so.
So if it was acquired by one party before they came into the marriage, that is
it's not
brought into the picture at all.
It's not, unless the person decides to bring it, add it to the pool of the marriage and make it a marital property, it is not. In fact, properties acquired before marriage, properties acquired by way of gifts, which is not as a result of the marriage. Because let's say, for instance, you get married today and a benevolent friend of yours comes and says, oh, because I'm donating this car to you, that's you and your wife, or your wife and you for your use. Yeah. That even though it's a gift, that will fall within the pool of property that came to you by way of the marriage.
Okay.
But if, for instance, your father is partner in his will, he says that this property of mine located here, I'm giving to my son or my daughter, that cannot be, that is an inheritance, that cannot be part of what we describe properly as marital property. And also, even though
one party would have acquired it during the marriage, it will not be part of what has to be distributed.
It will not be part of it.
Okay.
And also, there are some jurisdictions where they don't consider, for instance, damages obtained out of judgment. So, for instance, let's say you are knocked down by a vehicle, and then you go to court, and the court awards you damages for negligence on the part of the driver. That will not necessarily constitute earnings coming out of joint efforts of the parties in the marriage. Unless, of course, maybe one party can show that I was the one who possibly provided the financing towards the suit. So I'm entitled to a certain share. But if that doesn't exist, then clearly that will not also form part of marital property, so to speak, even though you got it whilst you were married.
So why is it important for you to mention that property acquired during the marriage, as though you separated that and then moved a step further to say jointly acquired?
Yes, so it's necessary to make that distinction because the law, as has already been discussed, also recognizes the right of persons to own personal property. So that right is not extinguished merely because you get married. You still hold that right. So there are instances where you may be married or you are married, but you want to acquire certain properties for yourself, like personal effects, your mobile phone. It's your personal property, which I am yet to come across a divorce where a party is going after the mobile phone of another, but possibly you acquire the mobile phone in the course of the marriage.
Right.
Yet you will not go after it because you sometimes believe that that is a personal property.
Okay.
And maybe, even though maybe the other person possibly supported it in a way, they don't really come after it. And also, like I said, the law has also evolved to a point where in the recent case, I think a year or so ago, the court took the view that where a property is developed pursuant to loans that are taken and are still being serviced, we cannot consider that, especially if that liability is on just one party who is servicing it, you cannot consider it as property which forms part of the pool of marital property.
So if it is the man or the woman who went to take a loan and they are servicing the loan, it's their property.
It's their property.
You cannot say it is for the both of us.
You can't say that it is for two of us because you got it, because the liability will attach to them only and they are the ones paying for it.
Okay.
In that case, your contribution may not necessarily be there. Even though you are married, it will not be something that you jointly pool resources to acquire. Because you must jointly put resources together to acquire, whether it is financial or indirect, which could be taking care of the home, feeding children, sweeping, and among other things. Yeah.
Now, Iris, the jointly acquired property which must be distributed equally according to the Constitution, that's like a very high level. The supreme law of the country says that if the marriage ends and there is property that was acquired jointly, it must be distributed equally. Nobody can do anything about that because that's a constitutional injunction on the court and everybody else. How does one show positively that this property is joint property? How do you explain this to someone who has heard that we have a new land law that says that, there is a presumption of joint ownership of property in the marriage unless the contrary is shown. And therefore, for example, a man who owns property in the marriage cannot get up to dispose of the property without the express consent of the wife.
Right. So when it comes to jointly acquired property, the Constitution actually says that it must be distributed equitably, not equally. So sometimes equity means 70-30. Sometimes equity means 50-50. So that's one of the differences that we must look at.
Thanks for the emphasis.
Equitable distribution of property. When it comes to the ownership or personal ownership of property, yes, the Constitution gives everybody a right to own property personally. In order to do that, you must show clearly that at every point in time during the acquisition, it was understood and agreed by the parties that this property is not meant to be enjoyed by the two of us. In the sense that we are looking at a situation, or the law is trying to cure a situation where parties will come and say that I acquired it on my own just for myself, and therefore you cannot enjoy it. What have you done to show that the other party at all material times understood that that property was meant to be enjoyed alone? Because, for example, there's an issue of constructive trust. If you are the legal owner, and that means that if you are the registered owner of a certain property, and it can clearly be shown that at every point in time, it was never anticipated by the other party that you did not intend that he or she would enjoy part of that property, you will be held to be a trustee of that property or that portion of the property on behalf of the spouse. So at every point in time, you must show that it was clearly understood that it was part of going to be property that I was holding. So for example, maybe your mother doesn't have a place to live. So I was building this house with the intention that it will belong to me. It will, because I intend to give it to my mother. It's a separate and different from where we have jointly built property and then you quickly go and hide it in another person's name. For that, there may be a constructive trust if the other person is able to show that joint acquisition and that intention that it's that person intended to enjoy that property, and to show that that person has actually acted in detriment to themselves. And acting in detriment to yourself it would be actually contributing towards it with the intention that you will enjoy it. So it's nuanced, and once again on a case-by-case basis.
What is okay? I almost said yeah. So Randolph, it wants to make a point, but I hope I don't forget to come to a question I have. Please go ahead.
So just to add to it, the difficulty, the law now as we have it operates on a presumption that property that is acquired in the course of marriage is property jointly acquired by the spouse. So if a party is disputing the joint ownership of that property, then the burden is on that party to lead evidence to establish that with this particular property, we cannot add it to the pool. So I am rebutting this presumption. So if you look at the law as has been developed over the years, and the shift from financial contribution and a part of, and excuse me to say women, because they are the ones who suffered the most with regard to this, the evolution of the rights of women to property in marriages. You will notice that there was an expectation on their part for financial contribution. So now what the Supreme Court and the law has said is that we are not necessarily looking at that financial contribution. Let's look at qualitative contribution as well. So if the contribution came in ways that we cannot quantify in monetary terms, but we can still see it as some way or some form of assistance offered to a spouse who was able to bring in the money, then let's consider that to be contribution. Let's weigh it against the generator of the
contribution. Some would say that's the Mensa and Mensa
contribution.
What form does it take so that I would not have given money as a spouse, particularly a woman, but I will still be entitled to a reasonable, or is it
an equitable share?
Equitable share
of them.
What will it take?
So for instance, if you're a spouse and you're not bringing in the money, but there are children in the marriage, you wake up as early as 4 a.m. to prepare them for school, you drop them off at school, you cook for the entire household, you do the cleaning for the household, you manage the household, you run errands for the household, you ensure that everything with regard to the management of the home and all persons within the home is moving smoothly, so that the other spouse, when he steps or she steps out of the house, doesn't have to look back to see whether everything is in order. The law considers that to be a contribution. So in simple terms, even sweeping. So and there's a reasonable basis for that valuation of that as contribution, because Samson, if you were to hire a nanny, you pay.
That's right.
If you were to hire a cook, you pay.
That's right.
If you were to hire a driver, you will pay. If you were to hire a cleaner, you will pay. So the services being rendered by the spouse who has assumed the role of managing the home has helped you to save all these monies that would have gone to the payment of these service persons that you are going to employ. So technically speaking, that is a person's contribution towards the acquisition of whatever assets we have acquired in the course of the marriage. That is why in the Mensa, at a point the court even took the view that even if the woman did not contribute financially, based on the facts of the case, they would have given her that share, because that is her contribution.
And that's a shift from a previous position.
That is
where the woman would have had to contribute financially.
Exactly. Because at that point, the law and the society, let me put it that way, did not recognize the role that women especially were playing in the management of the home. Because the position of the law was that whatever property that was acquired in the course of marriage is for the man. The woman only has more or less like proprietary a right to reside in the property so long as the man is alive. Once the man dies, it goes to the man's family. Even the children do not even have any interest in it. But thankfully, that position has seen a drastic shift, where we will not, in determining whether or not a woman has a share in the property acquired in the course of marriage, you have to look at financial contribution. No, the food that she cooked for you to come back home to eat at 4 p.m. is contribution.
That's right.
If she had gone to render that service to someone else, she would have gotten some money. And there are instances too where you realize that some men will ask their wives to quit their job and stay home.
That's right.
She was an earner. You asked her to come and stay home. So effectively, you have stopped her from earning money to manage the house. If you were to pay her for that service, possibly it would even be more than what she was earning at work. So if you've asked her to, with all her certificates, all the education she has acquired, she should stay home, you should be ready to accept the fact that if properties are built in the course of the marriage, you cannot claim it to be entirely yours.
Thank you very much. You're still here on The Law. This is your Legal Light. It is your Help Law. It's our weekly legal clinic where we try to help you to appreciate, understand the law, so your life will be improved. It will be a lot better. And I'm very sure, definitely, without any doubt, that we are doing exactly that for you this morning with Agri-Orleans, Iris Agri-Orleans and Randolph Chumesi Ankra. Now, Iris, you had begun by making a distinction between, the property for distribution, as in what is subject to equitable distribution, jointly acquired, and also financial. And you said something to the effect that someone has been brought to a certain taste and expectation. How is that, as it were, evaluated in the courtroom to determine that this is your expectation, or this is the kind of taste that you have been brought and status that you have become used to, and therefore that must be maintained. Who should maintain that kind of status and why?
Thank you, Samson. So once again, for that, we are talking about financial settlement or financial provision.
Right.
We are not talking about distribution of jointly acquired assets. So financial settlement or financial provision is monies that is awarded, is what we call a just and equitable award of financial settlement. Now, you cannot take a person from, so I would use a small village in the central region where I come from. I want to use that. So you cannot take that person from a small village where that person was possibly living off 1 cedi a day, 5 cedis a day, and then move that person to Accra, Cape Coast, then introduce that person to a certain lifestyle. That person maintains that lifestyle with you, then acts as a spouse, does all the things that he or she is supposed to do as a spouse. And then upon dissolution of the marriage, 15 years later, you say that, well, I picked you up from the village at the back of beyond. Go back and live on 1 cedi a day. Is it reasonable to expect that that person can go back and fit into that lifestyle? No. And that is the basis for that standard of living position. So you'll see that it says in section 19, it will say that the court has to consider the standard of living of the parties and their circumstances. So in order to consider the standard of living of the parties and their circumstances, the court will consider the income earning capacity. So the fact that you believe that I should, Mr. A or Mr. B should be able to pay 10 cedis doesn't mean that Mr. A or Mr. B will pay the 10 cedis. The court will look at the income earning capacity. How much does he have available to him? How much does he spend on his own outgoings? Are there children in the marriage that he's spending on? What else are his liabilities? How much is he bringing in? Before a court will make a just and equitable financial provision. So you, as the person who is claiming that financial provision, must show the need for the financial provision. Then the person who is contesting will show that that person earns only X or Y amount of money, and therefore that person cannot pay the financial provision or can pay only up to a certain amount.
Okay.
So income earning capacity, your financial needs, so how much you actually need, the standard of living, as I've explained, the age of the parties. You cannot marry for 20, 30 years, and then when you've both gone on retirement and you are the only person who has all the properties in your name, you say that, Madam A, go back to your village and go and live there. Is it reasonable to expect that she can take up a new trade at age 65, at age 70? So the age of the parties and the contribution of to the welfare of the family, what each party has done during that marriage. So it's usually for a financially stronger person and then a financially weaker person when it comes to financial settlement, which is different from the jointly acquired property.
All right. The phone lines are open now. You can join us with your questioning and go straight to the question. Now, let's get to that, miseducation. And I want to hear from the two of you. Is it possible that a spouse decides that during the marriage, property that he or she acquires, he will acquire them in someone else's name? And therefore, when the marriage ends, the other party cannot fall on those properties. Does it happen that way?
So to answer the question, you asked whether it is possible. Yes, it is possible. As to whether it's acceptable legally is the issue. Yes, you can. People do it. They buy assets, try to hide it from the other spouse with the aim of enjoying the benefits of it solely. Now, in law, we have what we call trust. And then we also have in the law of what we call tracing. So if in the course of the marriage, and don't forget, as we have already stated from both of us, that the law presumes that properties acquired in the course of marriage are jointly acquired properties. And the new Lands Act even puts an impediment in your way that even if you want to use marital property to secure a loan or for whatever it is, you need the consent of the other, and you can't even register it without the consent of the other party in your sole name. So clearly the position of the law is well established now. Now, if you acquire properties in the course of marriage, in the name of a friend, a family member, whoever or whatever it may be, it can even be a corporate entity. There are several ways by which the law can go after that property if the other person is able to show that this particular property, which is situated here or there, was acquired in the course of the marriage based on our joint efforts as spouses. Even though it is registered in the name of, it doesn't even matter whether it's a land title, even though it is in the name of Mr. Amponsa, this property belongs to my husband and myself. So, court, please declare me a joint owner or declare that Mr. Amponsa holds it in trust for both of us. But the fact that what needs to be established in such a situation is first and foremost being able to prove that it was acquired in the course of the marriage and was acquired based on the joint efforts of the parties.
Right. We'll get further into that. Let's, Owusu Charles, you're calling us from Malam. What's your question? Straight away.
Yes, I want to ask the lawyer. He did mention something like cooking, washing, house errands. When a lady renders such a service in marriages, and in terms of breakout, he needs to compensate the woman for that. Then if I have to compensate a woman for that, then actually, what is the responsibility of a woman in marriage? If she performs all these things and then I have to pay her for that in terms of marriage, then what is her responsibility in marriage?
Okay. Thank you very much. Charles, well, if that is the woman's responsibility, then it must account for something, shouldn't it? Okay, then, apart from Charles, a couple of questions. But so, you want to take that quickly?
Legally, a spouse, whether woman or man, has no obligations imposed on them by law to perform in the marriage. Whatever they do is what they are bringing on board to assist the success of the marriage. You cannot compel performance from them because it's not their obligation. So to ask what is the obligation of the woman in the marriage, respectfully, is to assume.
But Iris, don't we hear about conjugal obligations and all of that? So people have obligations in marriage. What do you say to Charles?
You see, at every point in time, we'll have to recognize that both parties have a responsibility to make the marriage work.
Right.
You'll see, and that was one of the things that my colleague Randolph said. He was talking about the cooking and cleaning. In ordinary, in normal Ghanaian societies now, sometimes you have nannies, and then especially when you come to the middle class persons, you have a nanny, you have a chef, you possibly have a driver. But there's a mental load where somebody is actually running and ensuring that the home is running. Once again, you also talk about things like, and you mentioned that issue of the person who had put properties in the name of their mother, etc. The requirements of that person, that footballer who had put properties in the name of his mother, is different from the requirement of a civil servant in Ghana. So the fact that that person's wife accompanied him on those trips, on those business engagements, etc., it is actually even services that are rendered. So you see, it's on a case-by-case basis.
All right.
You cannot impose any obligation on anybody.
Okay.
Let's must be watched by both parties.
Right. Okay. Charles, I hope you are satisfied now. If you think that the man's job does not include doing the things that we see women do typically in our African society. Abraham, you're calling us from Takoradi. Let's hear you. Sorry for keeping you waiting a bit.
Yeah, thank you. My question is, if you marry traditionally and you divorce, then you make a will. When you die, how will your property be distributed? Will the will supersede everything that you had said?
Okay, thank you, Abraham. Even though it doesn't seem exactly related, but we can answer you straightforward. Yes, answer him. If you make a will, does your will supersede everything else in the distribution of your property when you are dead?
So if you look at the same Article 22 that we are discussing here, it actually states, the very first provision or opening, I think one of the early provisions there says that a spouse shall not be denied reasonable share in the estate of a deceased spouse. So in your will, if the will does not make provision for your spouse, the court has a power to even revise the will for you. So clearly your will is not absolute. If the will does not meet the legal standard, the courts can interfere with it and make reasonable provisions out of it for your spouse, and in some cases even for your children. So your will is not absolute.
Okay. There is a question, says that in case of the loan, you spoke about loan, liability is taken by one for expansion of a company. Why is this liability not shared equally if the proceeds of this expansion would be shared during a divorce? Aris, do you understand that?
Could you go over it again so that it's a company, it's a separate
you take a loan, a spouse takes a loan for the expansion of a company. It says, why is this liability not shared, especially if the proceeds of the expansion would be shared during a divorce?
Well, so once again, we look at why or in what capacity were you taking the loan for the company? Because you, as a company, it's the company that takes the loan.
Doesn't it matter that the proceeds of the company is for all of us?
No. So it is the shareholders that enjoy dividend.
Okay.
What do you mean by proceeds of the company? So are you taking the loan as a shareholder on behalf of the company? Why is the company, which is a separate legal entity, not taking that loan?
Okay.
If it is a shareholder loan, then you are loaning the money to the company,
right,
and the company will pay you interest. So it's a very funny question.
Okay. In some 30 seconds, Iris, let's hear you. What advice will you give generally to members of the public when they are talking about divorce and property-related issues? 30 seconds.
I think that basically one must be honest with the spouse. If you intend to own property alone, just state it. If you think that the marriage you are in is such that you cannot safely own property and you want to own it alone, just be honest and leave.
Thank you very much.
Don't attempt to hide things.
Okay. Thank you very much. Yes, Randolph.
Just my love.
Yes.
So just to say that we must all understand that the position of the law as it stands now is that in the course of marriage, any property that is acquired is presumed as a joint property unless otherwise established. That is what we must always bear in mind.
Right. Thank you very much. My guests have been Iris Agrioliens, who is partner, Bayo & Co., and Randolph Chumesi Ankra, partner, Morrison Chumesi and Partners. And we spoke about distribution of property upon divorce. I'm Samson, Lardy, Anyenini. This has been The Law. It's your legal light. It's your help law. Join us next week for another edition.